and take all lawful measures to take the ongoing investigation to a logical conclusion. It may not be appropriate for us to express any opinion at this stage, except to observe that there has been an unexplained delay. There has been an unexplained delay on the part of the investigating, on the part of the ED.
And for both.
ऐसे तो यहाँ तो दोनों का इकट्ठा लिख दूंगा यहाँ पर ऐसे तो similarly a report in sealed cover has been filed by CBI in bracket risk number 3, which has been opened and perused. It seems that a formal FIR was registered on the basis of a complaint received from State Bank of India. According to CBI, the complaints received from other banks, stroke financial institutions are also being investigated by enlarging the scope of the said FIR. Such a report adopted by CBI, apparently, does not seem to be in conformity with the procedural law, as is complaint, even if it pertains to defalcating of public funds, is based upon its own unique set of facts and therefore would constitute an independent offense.
Also touch upon 17. Also touch upon 17. Also touch.
Furthermore, it is imperative from the CBI to investigate the conduct of the bank authorities as to whether the financial assistance was released from collusion and connivance with the management of the companies in default. In this vein, the reference by CBI to Section 17A of the PC Act is totally misconceived. We direct that regardless of any such provision, the CBI must look into the nexus, stroke collusion, stroke connivance, stroke conspiracy, if any, and for that purpose, all lawful measures for taking the investigation to its logical conclusion be adopted. Next paragraph. We may hasten to add that both agencies, namely ED and CBI, have already taken their own time in swinging into action, and any further delay will not bring, and the further delay put it in a positive way, and we therefore expect that both agencies will act promptly, independently, fairly, and in a dispassionate manner. As per let status reports by both the agencies be filed within 4 weeks post the matter for further consideration on so and so date.
Only
One last thing.
One small request, only.
Since
Mr.
your
Paschim.
lordship is now monitoring this matter, there is now serious apprehension that the owner of all these companies, my lord, the person who owned these companies, he may flee the country. Now, they have not arrested him. They have
Why
not
should you
even
make
issued
that
a
statement?
lookout circular.
I am in India, I am
They
before the
have
court,
not even
I am
issued
not
a
running
lookout
away, I
circular,
am not going anywhere.
which will prevent him from fleeing the country. So many people, my lord, with tens of thousands of crores outstanding have fled the country.
There is an
At
LOC
least- at
against
least
him, my lord.
There are several LOCs, I have not gone, I have not attempted to go, I am, my lord, working in my office in these companies even today.
That I think that having been issued, they can't now.
And I am not going, my lord, there is no question.
Lookout order.
Lookout
Should issue a
circulars are
lookout
issued.
circular.
There are several of them, not one.
They can't allow him to flee the country. At
Arre
least a
bhai.
lookout circular, even if they are.
Why is
not-
my friend making this statement, my lord? Is there any material to say that I have fled the country or have fled the country?
You have.
We have repaid 20,000 crores in the last 3 years. If I had to go, I would have fled earlier, not now.
a per-
Why do you make these kind of statements?
Now because
Just because of the press?
Because the court is monitoring the matter now. That's why I'm saying.
So where is the,
That's why.
show me one stretch, one shred of evidence to suggest, my lord, that this man is running away.
Solicitor General, you, whatever necessary steps are required, because we do not want anything to happen which may frustrate the ongoing investigation.
I understand.
You
But
must
a
take-
line from your lordship's, my lord, would really.
We must take whatever preventive or other measures are required to be taken. We do not want that investigations are hampered at any cost.
Observation करने के लिए सब सिद्ध हो रहा है.
My lord, statement, I will not leave the country without the leave of the court. What more is required?
Lord,
Just to make, my lord, allegations against us?
My lord, only a minute, only a minute. My lord,
At this
my lord, there is something I want to say at this stage.
stage, Mr. Prashant Bhushan, learned counsel for the petition.
R5, my lord.
My lord, before your lordship dictates, my lord, one thing.
Huh.
My lord, I respect Mr. Rodgi's statement, but in past, my lord, he has also burnt his fingers. He made a similar statement in favor of one of the clients, my lord, before Delhi High Court, and the person did flee. I'm not saying, my lord, about this person.
But he came back and he paid 5,000 crores to this government.
That-
Let's be
But
very
after
clear.
5-6
Once
years, but
he-
sometimes,
once
my
he-
lord, statement becomes, my lord, embarrassing for the
Once
counsel.
he is out of the country, what good is a statement? Once he leaves
My
the
lord, then there is no, my lord, there is no reason to trust anybody. Then there should be no revised statement should be recorded about anything.
in a
What
matter
is this
of
kind of argument?
time.
What we will
My
say
lord,
at
one
this-
will flee
at
after
this
the
stage-
statement for if
At
100
this stage,
people.
Mr. Prashant Bhushan, learned counsel for the petitioner, states that,
Very, very unfair.
that
Make these allegations.
owing to the
He's responding.
alleged, owing to the amount of alleged fraud involved and the action now and the matter having, being investigated under the supervision of this court, comma, there is every likelihood of the principal accused fleeing from country. On this, Mr. Mukul Rothgil and senior counsel representing respondent number 5
Yes, ma'am.
states that that his client will not leave the country without prior permission of
Of this court.
without prior permission of this court. Full stop. Mr. Solicitor General of India and assures that all remedial actions,
Preventive actions.
preventive
Preventive.
and remedial actions will be taken to ensure that no impediment is caused in the ongoing investigation.
Yes, certainly.
That's fine.
Because the
I'm
other,
grateful, my lord.
because we haven't had the advantage, of course, of these sealed envelopes. We really don't know
They
what
are
is in it.
pending
We
investigations.
know this we know this a bit about the affidavit which the Enforcement Directorate has filed. So, Brother, your Lordship may give us 3 weeks because at this stage,
4 weeks we are done
yes, for a counter affidavit.
for counting.
Yes. Please do that because this on denials. We are denying these allegations fully, Milal, because otherwise the court ultimately is
We
going
are
to
not
take
taking-
appellate remedy.
That's why we are very careful in
Yes, Your
using the
Lordship.
word.
We have seen them.
And
That-
we are also granting you time. 4 weeks.
Absolutely.
I'm grateful, my lord.
Obliged to.
Lord, kindly come to page number 63, my lord. Lord, 2 years after construction of the overhead tank, kindly come to page 63, my lord.
Commercial loans also provided with the bank. And I have paid everything. I have got no due certificate.
63, my lord. My lord, we had
Yeah.
constructed a overhead tank, my lord, for the purpose of this Ilayangudi village. And my lord, we are
The water tank.
a water tank. And my lord, a small panchayat office is there. My lord, on a land, my lord, disused land, my lord, which was originally, my lord, a village pond and later classified as, my lord, a disused land. My lord, in fact, we have an hydrological report also saying this construction will not anyway affect in the other part of the land, my lord, which is retained still as a pond. My lord, the High Court, my lord, directs us, my lord, to remove, calling it as an encroachment. My lord. And thousands of, my lord, yes, my lord.
And water, public use.
And 3,000 direct beneficiaries of this water. My lord, fresh matter, my lord, coming for,
Issue.
some delay also is there.
Delay condone, issue notice returnable on so and so date. Meanwhile, operation of the interim judgment of the High Court shall remain still.
Lord, R1 is the writ petitioner, others and all were respondents, my lord, along with the
So,
former councillors and all.
so notice returnable on so and so date. जो है डिले भी इनको सुनकर के कर दे तो ज्यादा delay. Review is 107 days.
हाँ, जब ज्यादा नहीं है उसके बाद.
And bill 380. So 900. Returnable on so and so date.
Stay, my lord.
Number one being the contesting respondent, comma, the service on pro forma respondents is dispensed with. Respondent number one may be served through dusty notice also. Meanwhile, operation of the impugned judgment and order of the High Court shall remain stay. Consequently, the water tank, there shall be no demolition of the Panchayat Bhavan or the water tank.
Grateful to you, Lord.
Okay, please, your lordship. This is another interesting kind of bank fraud. It's, every day, my lord, they come out with unique,
objection for saying this one.
unique ways.
Absolutely.
Graduation हुआ था, दो graduations.
Your lordship should see how a genuine transaction is put into so much of court pressure. We should give us 2 minutes, my lord.
I appear for.
Genuine commercial bank transaction put into so much of pressure and anguish, my lord. Please see the number. We have recovered 116% of the loan amount. And now he wants an inquiry. Absolutely a roving inquiry without any basis. Please see the numbers.
They are so worried that they don't.
No way.
No, this kind of slings in the dark. What the High Court says.
Mr.
at face
Bhushan,
value.
you have also
Highly
to understand that this is a commercial transaction where the ledger value has already been
Recovered
achieved
and more.
through the auction. Then
No, my lord, ledger value has not been recovered.
that's
In fact,
the finding, sir.
no, the
Please.
company itself says that they have made a profit of so and so because
Oh,
of this one-time settlement. If your lordship now turns to page,
Kindly turn to page 30 of the.
actually, my
High
lord,
Court.
at page,
Page 30.
we have analyzed at page 189, what was due and what has been recovered. By the, if your lo-
Come to page 9, 7.2. It
Yes,
is
7.2.
116% of the ledger.
Please,
value.
I got the calculations. Lordship may see the
that is,
calculations.
on- that,
This is not able.
that is only the principal amount, not with interest. What was due with interest is, my lord, given at page 189. Otherwise, there would be no need for a one-time settlement. The only reason why they entered into a one-time settlement was because they said, and the bank said that, look, now the property has been devalued from 2,600 crores to 970 crores. Something very astounding. In 2021, my lord, this hotel was valued by the same valuer for the bank at 2,600 crores. 3 years later, in 2024, the same valuer values this same hotel at 970 crores, 1/3 of what he valued 3 years ago.
What was the mode of auctioning?
Mode of, no auction. What they said was,
Two options.
It's a settlement.
what they said was, we will enter into a one-time settlement, and the one-time settlement,
Concept law, comparable, that was wrong. If you have a hotel use, not the value is lesser than a commercial use, that's why it was done. And after I had paid everything and obtained a no use, this petition is
My
filed.
lord,
How much was the total loan
yes, my
liability?
lords may see, my lord, the court has gone into, lordship may see the sheet of paper,
I'll
only one
just
sheet,
show-
my lord, which we have given to your lordship.
if you're
And
not,
see the second sheet. Only two sheets were,
Tell us, how much was the,
my lords may see the numbers. Yes, your lordship may see the numbers. Loan sanctioned is
loan with
242.61 crores.
240?
I have given the sheet, my lord. I have given a sheet of paper with these numbers. Yeah,
Very
please.
good.
Yeah, please.
that was the original
Yes,
loan.
one minute, please, Mr. My lord, loan sanctioned is 242.61 crores. Ledger balance at the time of OTS is 226.54 crores. Total amounts recovered is 414.6 crores. Profit of 172.
No,
It-
Mr. Venkataman, this 242 crore was given in which year?
I'll give the year in a minute. I'll give it in a year in a minute.
March
2015.
20.
2015.
15.
Yes.
Now, out of this principal amount of 242,
They have paid so far, 400, including all the settlement, 414.63, line 3.
that 414 is paid only in OTS.
No. If your lordship sees the second line, 242 came down to 226 at the time of OTS because interest, always bank takes interest first. So once OTS has been compounded, the total amount recovered by the bank is 414.61 crores. And my lord, the date of declaration of the NPA is 31/12/2020. Bank sanctioned a one-time settlement of 265 crores.
No. This 414 crore is paid when?
No, my lord, since inception, my final payment was made in 20.
Actually, my lord, at a glance, your lordship can see.
OTS amount in 2023.
In the COVID period, the hotel was empty, we were declared in NPA.
NPA.
The hotel is empty, it can't pay anything. That's across the
For
country.
3 years.
When they created a default, we challenged it. He said, we are not a default, when the hotel is not establishment. can't-
Mr. Rothgi, if the account is declared NPA
Yeah.
and the assets of the borrower are valuing more than what the total due amount, in that case, normally, what these bank people do, they always go for auction. They don't allow a poor resident.
No, we exercised option twice.
100 square yard house, they will throw him out, will put him in auction because
We went for auction twice and it failed. We have exercised that option. It's not that bank has not done it and it failed.
We questioned it, in COVID, the hotel was empty, we were suffering a loss of 100 crores.
किसी गरीब आदमी को इसको ना
And my lord, please see
Prior to COVID,
on the valuation.
1 minute.
prior to COVID, we were fine.
There.
COVID did not created a problem for all kinds of luxury establishments like hotels. We were questioning our NPA. Finally, this was the figure which was being.
No, but this unfortunately settlement is in 2025.
Now, yes.
2024.
So before, in 2025, on 24th January 2025,
Yeah.
before that, when did you put the hotel for auction?
Yes, for 2 days. We have done it twice and it failed. We'll give the dates. Twice we have done the auction, we'll give the date. Asset reconstruction auction will not took place in 2 dates. Lord,
2023.
P6 and P5, my lord. P5 and P6. One is, my lord, dated.
कहाँ है print?
2023. Yes.
बेंच के लिए है बीच में फोन आपको 100 मार्क्स है
5/9/2023 and my lord, 29/11/2020.
No, no, 5/9/2023, what was the highest bid?
No bid was received in both.
After, then, in 5/1993, first of all, please show us the records of the auction. Please produce the record of the auction.
We'll do that. Will you lordship kindly
After
turn?
1993, 2023, then you are entering into an OTS on 24th January 2025.
Yes.
Even a layman in Delhi can take notice of this fact that what is the value of a five-star hotel in Delhi?
Just
Lord,
see.
There was a moratorium stay for
Just see-
3 years
see
because of COVID.
Page
So, my lord,
That 3 years is
High
over.
Court, because of a High Court order.
If your lordship
That
just
3
sees.
years is over when in 2023 you try to auction it. That
Yes.
means that 3-year moratorium period was over.
Yes, yes.
Now, from 23 to 25, when anybody on the earth can take judicial notice of this fact that the value of real estate properties are rising, and you have a 5 or 7-star hotel here, you enter into an OTS. Before that, you don't make any attempt to auction it.
But we have done it. My lord, with great, there are 2 facts have not, well, the High Court has recorded 2 facts. My lord,
So
2,
please produce the records of the auction. We would like to see it.
Yes.
Your lordship, just 1 second.
In fact, my lord, if your lordship turns to page 252, just turn to page 252.
my lord, nobody
is-
can then come, enter into a
Just
commercial understanding of an
check in
OTS.
250.
When, my lord, in IBC process, 90%, this is a case of a recovery of 116%. Your lordship is now, my lord, to say that this should be,
As a matter of principle, in the commercial wisdom of the banks or the financial institutions, we will not interfere. There is no question of it. But when we are talking of your commercial wisdom,
yes,
we also know it very well that you are not a private entity.
no doubt,
The funds which you have are the public funds.
no doubt, my lord.
These are this money belong to the people of this country.
Yes.
Therefore, your commercial wisdom is for the purpose of giving undue benefit to a person, or it is to protect the public interest.
Which is not
That
their
part will
case.
have to be
With
investigated.
greatest respect, my lord, today, the case of the petitioner is a roving inquiry. He doesn't make out any case.
We are not concerned about the petition.
Yes, answerable to the
He
court.
might have been- we will go to the extent that the petitioner has been planted by some rival. Somebody who wanted to buy the hotel couldn't buy. Let us take it like that, worst part. But now that a fact has been brought to the notice of the court,
Yes.
we should satisfy our conscience that the things have taken place in a transparent
Yes.
and fair manner.
Lord, which is what the court has said.
If your
We'll take the
lordship
findings of the court, my lord, but finding after finding.
just sees one page.
Hotel was not, my lord, having any default prior to COVID. It suffered a default. The government of India, my lord, also issued circulars in regard to this period of default. If I have come out of it, they did try to sell. After that, I am back on my feet and I have paid. Is it a case?
Mr. Rotigi, we have no difficulty. Every day in, day out, in matters before us,
Yeah.
the plea taken by these very banks is, we will not enter into any OTS because the value mortgage by them is much more than my loan amount. Therefore, why should I go into OTS? This is the consistent stand they take before us,
Look at-
that we are not going to accept any OTS
My lord, look-
because we have an asset, we will auction it and we will recover entire amount.
But, my lord, is it appropriate that a man who suffers, my lord, great losses during COVID, not a single room in the hotel, my lord, was functioning?
No, we are talking of, had the settlement been in 2020,
Yeah.
things would have been different. The settlement is taking place in 2025. This OTS is in 2025,
Yeah.
when the entire, hospitality sector, the hotel, they are flourishing.
Yeah.
They have wonderful business, each one of them making money. A 5-star hotel in Delhi has its own value. People know it very well. Who is going in the street, who is going to believe it, that this hotel has a value of 300, 400 crores? When the value might be 4,000, 5,000 crores?
It's not, they do, well, 4 valuation reports are
Debt
offered.
was only 200.
Four.
The debt was 200,
Fine.
250. It is settled at 400.
Why is it
Therefore,
not?
two things, let them produce. First, produce your ledger books that if going by the rate of interest and all, as per the original loan agreement, what was the total amount as on 24th January 2025?
We shall, my lord, this, a special committee comprising of a retired judge and 4 other bank has come, Lord, this OTS was decided ultimately not by the bank alone. It had 5 people in the committee headed by a retired judge, which decided what should be the OTS amount.
Then immediately produce this report. We would like to see the report of that learned retired judge also.
No, it's
Please
a-
produce that report.
I just want to make one small request, Your Lordship, sir. I'm appearing for the bank. The committee consisted of 5 persons, a RBI nominee, a Government of India nominee,
If your lordship just sees,
besides the bank official, there's a RBI nominee, a Government of India nominee, and a shareholder nominee. They were all independent persons who had nothing to do with the banks playing any fraud in this case.
No.
And it kindly, therefore,
We have no doubt about their independence, Mr. Attorney. This all depends upon what the facts are.
no,
produced
Your
before
Lordship's
them.
question is certainly well placed, but the question is,
It is something like whatever in a writ petition or in counter affidavit is brought before us, based upon that set of facts, we take a view. Our view, despite the fact that nobody will question our bona fide, nobody will question our independence, but still our view can be erroneous.
certainly, we go by that.
It's not brought on
We
report.
certainly go by that proposition, but the High Court said, I've looked into all these aspects.
Yes.
High Court goes into an independent of the settlement committee. High Court says at 12:30, I
These are
don't
detailed-
find these are roving inquiries
Yes.
for no good reason.
Absolutely a non-serious,
inquiry.
my lord, non-serious, vague, bald, sweeping allegation on, my lord, a bank, on a my lord, we are not defending every transaction. We ourselves come. But, my lord, to say that therefore every transaction has to be, my lord, 5 million transactions happen every day. If you are going to put, my lord, a spokes to, my lord, through a process to say that this should, my lord,
Mr. Venkataraman, unfortunately, we are not saying that every transaction, but many of the transactions.
Certainly,
that
my lord,
take
but
place,
we
and
are-
particularly
Provided.
under this, the direct or indirect umbrella of this IBC.
yes, yes, my lord,
These have become a very, very doubtful,
Absolutely.
a very doubtful manner. A poor lady, a widow woman came to this court. She was before us with tears in her eyes. She wanted to pay 30 lakhs to a bank. They refused because they wanted to 46 lakh. She lost her husband. That's why the default was committed. We had to come to her rescue only to protect her residential house. When question of their case, they said, no. The value of the house is more than 50 lakhs. We have to recover only 46 lakh. Why we should enter into OTS?
Those,
This
those-
is the stand, these commercial wisdom people take before us.
There are-
And when the question of a 7-star hotel come, the stand is altogether different. Why our conscience will not click? Why should we accept it?
may I only persuade on one aspect?
Please produce the records. I would like to satisfy myself.
Your Lordship will do that. I only want.
My,
I-
so will be my brother. Let the original records of
The settlement.
the bank, complete details of the loan amount which was due as on 24th January 2025, the report of an independent valuer, if any, assessing the
Four valuation should will be produced.
market value of the hotel as on 31st December 2024, that is immediate before OTS, and other relevant records be produced.
Well, there are four valuation reports converging on value, except for the one odd value report, which said, well, this is a hotel. We can't sell a hotel. Well, valuation demands, hotel cannot be sold as some industry. One odd valuer gives a report of 2,000 crores, which my friend is relying upon, who says it's a commercial property. It's and one whole building is left out from the loan. Loan is not, ultimately the mortgage is only limited to a few sections of the whole. He values the whole. He values the whole as commercial, contrary to four bank authentic valuers who all confirm what this value of this hotel would be at a given point of time. Four concurrent valuation reports. Well, the High Court spent a lot of time. Well, we'll certainly persuade your lordship. No difficulty.
Venkataraman,
But only thing, my lord,
we have recently, incidentally before my bench only, we have dealt with the auctioning of 2 hotels in Kerala. We have seen the people come forward to buy hotels also. There is absolutely, it's not that people, the prospective buyers are not available.
we have no difficulty in producing.
Understandable. Suppose you say that I have tried my best in December 2024. I could not auction it. I did not get a single bid. And therefore I had no choice but to go for OTS. We will accept it.
That's precisely
That
what
is
happened.
commercial wisdom.
Precisely what has
What has
happened.
happened?
Not even otherwise.
We will produce the records.
Things have lot of.
We'll produce the records.
just see one page, my lord,
Which I
page
suffered in
page
COVID.
252.
Why should the hotel be sold?
Two-
Apart from that,
We are not saying.
it's not that I was not a default.
If a borrower,
Siphoning
Mr. Rotgi, if a borrower, small or big,
Yeah.
if he can save his mortgage property by paying to the bank a reasonable amount, no difficulty.
Correct.
But not in this manner. If at all, it seems to be.
I
Therefore,
think, Lord, your lordship will be satisfied on the manner, Lord, I'm sorry, but your lordship will be satisfied, I think.
Yes,
Lord, this
yes,
is,
Lord.
Lord, this is an
I would
litigant
never
who is
stand for
just
it, my lord. Your
going
lordship
hammer
can
and
trust
tongs
us.
will
We'll show anything.
satisfy your
There's no
lordship.
difficulty. We'll show it, my lord.
Just
Absolutely no problem.
One page.
Lord, the
page
other issue will be,
252
can you really upset
of the
cases
paper
which are done in this manner?
when complete contrast cases come before us, we get disturbed only because we do not know what's happening.
Absolutely. There we are with your lordships.
But your lordship will be satisfied.
We'll have to pick the oranges from the apples, certainly.
The OTSs are happening in this country. If not
Yes,
every
yes.
matter is.
Lord, a very, Lord, a
unless
very,
there is any
we say this with a sense of responsibility, an extremely genuine OTS transaction is what has been brought unnecessarily into scanner. That statement we will make it to
Say
the.
notice to responder 4 and 5, 4 to 6 only at this stage. Number 1, notice to responder 1, 4 to 6, and 4 to 6 at this stage. Then also report will be produced. This is up to-
Therefore,
I am obliged.
Oblige your lordships.
Ah, chalo.
But office report shows on 4 earlier occasions SLP is dismissed.
May I just place my matter, I'll place all of that, I'll place that, I'm for the petitioner. This is a writ. The only question, my lords, I'm pressing in this writ is my prayer A. What is happening? I'm not seeking any relief in respect of the matter, which is prayer B. The only relief is prayer A. Your lordships will have at page 17. What is happening in the state of Telangana, my lords, is
Mr.
that
Prasad, how
Yes.
many time your petitions will be entertained? First
plus
of
no
all.
repetition. Plus what has happened is page 237, your lordships, I had come up in a SLP all the way, and at page 237 is that order where the liberty was given. My lords, may just hear me for 1 minute. I see that, my lords. I have come in a SLP. Let me explain that. And the liberty was given at page 237. Your lordships will have that order.
File SLP. Please see the order.
Yes. My lords, page 237 is the SLP. And my lords,
Remedy. And you file another SLP challenging this.
no, my lords, I have filed only one SLP that was knocked out on the point of delay. The question was never considered. That came before Justice Narasimha's bench. The bench observed that earlier order. Yes.
Mr. Prasad, then
Yes,
that means if we dismiss the SLP, we decline to entertain SLP.
Yes.
According to you, the second SLP is maintainable.
No, this is a writ petition. This is a writ. My lords, the court indicated that please, we are not going to, because against the same, my lords, against the same order, the question, only the legal question, because in the state of Telangana, well, the court indicated that if you have to move, please move a writ. That's why that gave me a liberty. I am not seeking any relief in respect of this matter, but what's happening in Telangana, your lordships will just consider one thing, my lords. What's happening is reserve candidates are being counted if they are meritorious against general seats. So, my lords, which is incorrect, because the law is very well settled. If I on my own merit make it in the general, then it has to be treated as I am.
SLP, please.
Because the SLP was dismissed on the ground of delay. So the High Court also didn't engage with this issue. The court at page 237, that's the order I had myself appeared, indicated we can't engage in this because I have dismissed an earlier order, earlier SLP against the same matter by some other party. Therefore, if you have to file a writ. That is why the liberty was given at page 237. And pursuant to that, I am filing. I am not seeking any relief or stoppage of the process here. I am only saying my lords will settle the law so that for future there is no problem in Telangana. That's the only prayer. This your lordships may not interfere. My lords may record my submission straight away. I am not seeking interference with this process now. Because otherwise every year this will be happening, my lords.
Thank you very much. We will not entertain this.
All right, my lords.
The petitioner has already lost the first round of litigation up to this court with dismissal of SLP civil number 16170/2025. So we are just of the view that the second round through this litigation is wholly misconceived, misdirected, and not maintainable. Dismissed.
Great.
Because I'm for the petitioner, my lord. These are two matters, my lord. My lord, similar matters have been, my lord, decided, my lord.
But these are fresh matters.
My lord, these are fresh matters.
Fresh. Any matter already pending where we can tag
My lords, as per the office report, no, my lords.
issue notice, trustee, liberty to serve the state through standing conflict.
Most grateful, your lords.
In the earlier notice recombination. Item 6. Already dismissed.
Please, your lordship. Lordship, this particular matter, as per the office report, this is already.
Similar matters have already been dismissed.
Yes, your lordship.
Same order. Item 7.
Wait, please, Lord. But I've just set out these, and just see the pleadings. Look, just see the pleadings against defend number 17. I've just put them. Just hand that up. I've handed it. My lords may just see this. Look, I've just summarized, I've set out the pleadings against 17. Just see that for a moment.
Apply order 1, rule 10, discretionary relief. Why?
Order 1, rule 10 2, but just see the pleadings here. Just see that for a moment. This is not, it's a case which.
But a case cannot be maintained against a shareholder when the cause of action is against the company. That is your argument.
No, but there's nothing against the shareholder. Just see the pleading.
That's what I'm saying.
Ultimately, even against the shareholder, there should be some pleading. Just see that pleading for a moment. Give me, just indulge me. I'm not asking your lordship to open the papers. I've set it out here. Just let me read that, lords. I've set out in extenso. I've reproduced it exactly. Just see, my lords. The solitary pleadings in the plaint with regard to D17, plaint is from 38 to 107. It's a 90-page plaint. Para 18, the 15 to 19th and 21 to 28 defendants are shareholders of first defendant and are therefore beneficiaries of the trades done by first defendant on the plaintiff's exchange. Para 91, the plaintiffs state that in view of the fraud and default committed by the defendants are jointly and severally liable to pay the outstanding amount with interest in respect of the said outstanding trades to the plaintiff. Para 111, the plaintiff therefore submits that this is an eminently fit case to secure the claim of plaintiff by attachment of all the assets of so-and-so, so-and-so, so-and-so defendants, since the liability of first defendant admitted by them runs into hundreds of crores of rupees, and the defendants are consistent with an intention to defeat and defraud the claim, which is manifestly evident by the act of restricting inspection of exchange designated warehouses. Para prayer is, this honorable court be pleased to pass a decree and order directing first, third to 41st and 45th to 50th defendant to jointly and severally pay 937 crores. Now, they relied before the High Court on this para 87. Just see overleaf. Para 87, the High Court just merely sets out the para. Just see para 87. It is pertinent to mention that from September 2009, when the first defendant commenced trading on plaintiff exchange, till August 2013, the management and the affairs of first defendant was run by the 6th and 7th defendant. In fact, 6th and 7th defendants were actively involved in the transactions entered into by first defendant on plaintiff exchange. The entire conspiracy to defraud the plaintiff exchange was conceived of and orchestrated by 6th and 7th defendants. It appears that the companies owned by 6th and or 7th defendants and other companies firm, which in turn were owned by individuals who are related or connected to 6th and 7th defendants, benefited from or participated in the fraud. The directors, shareholders of first to fourth defendants are either family members of 6th and 7th defendants and or people accustomed to acting on instruction. I'm not a director. My father
was a director.
he resigned in 2013. Suit is filed in 2021. 8 years after he resigns as a director.
And see,
No averment against my father.
the Roman 9, clause 9, Roman 9 of paragraph 87, that the shareholders are in collusion with the directors in respect of the fraud.
I'm not a shareholder.
You are a shareholder.
I'm sorry.
Paragraph 18.
It's a public limited company.
I'm a shareholder of the company. Your plea for dismissal is no dividends have been declared, so there is no.
I'm sorry, my lords. Please just see the law laid down by your lordships. This is this opens
The law
up.
laid down by us is not to substitute a discretionary order.
No, this is not a discretionary order with respect.
Absolute discretion.
Not 711 lies even with regard to if the entire plane can be rejected against one
Don't
defendant.
make advance arguments on 711.
Your lordship
Your prayer is under order 1 rule 10.
and under 711,
711A. If you argue
No
on
cause of action.
711, you are out of court.
Lords, your lordships
Cause
are
of
well in
action is made out. Simple.
I'm not, just see, I've set out the judgments also in this note. I'll tell you what. In Church of Christ, your lordships have categorically held that even with regard to an individual defendant, if the entire plaintiff can be rejected, 711 lies. Now there is no cause of action shown against me. Just making a bold
Sir,
statement.
can entire plaint be rejected?
I'm sorry, Mlad.
Can entire plaint be rejected when there is an allegation of fraud against?
Entire plaint has to be rejected. There's no allegation of fraud against me.
Doesn't matter.
Just a.
For that, what the remedy?
No, there has to be
Order 1
some
rule
basis.
10, order 1 rule 10(2) will make your defendant a party, a misjoinder. So for that, it's the discretion of the judge to keep him as a proper party. Simple.
Look, I'm
If it's not a necessary
saying
party, he's a
your
proper-
lordships have said that just by some artful pleading, look at the nature of the pleadings here. With this nature of pleading, every shareholder of every company will.
Mr. Singh, please come to page 26, opening line of ground C.
Page 26, Milord.
Page 26, opening line of ground number C.
I'm sorry, just give me a moment, Milord. Ground C, the High Court failed to appreciate that in these circumstances, the petitioner only being a shareholder of. Yes, I'm a shareholder of defendant number 1. The description is only that I'm a shareholder, nothing else. Which means lacks of, in every claim against a company, lacks of shareholders can be roped in as defendants.
We agree with you. He is not a necessary party, but he can always be treated as a proper party.
But
That's
there should, some averment against a party. I can understand if there was an averment that apart from being a shareholder, I have in some manner done some act, any act, even one act. There's nothing here, not a whisper.
Where is your most respected father in these days?
I'm sorry, Millet. Well,
Where is
really?
your most respected father in these days? The whole country is eagerly waiting for red carpeting for him.
Look, only one thing, look, then let it be clarified that I can only be a proper party. Now, here, please see, if there's no absolute absence of any averment, not a single averment against a party, Millet.
Not a case where we will.
Please, Your Lordship.
Appeal for the petitioner, my lord. Lord,
Yes, I to meet.
yes. My lord, without hearing me on the first day, my lord, and then I've got everything. Environmental clearance, consent to operate.
Joint in
And approach the High Court.
No, I tell your lordship, my lord, they've passed this order and now the next date is April. I'm running, my lord. I know the stone crusher, the moment you hear it, everybody nowadays has a prejudice. But then, my lord, for 3 months, I'm a small entity. I opened in December.
April, so you can request the.
They've just, I had lots to say without hearing me. At least issue notice to me, my lord.
Therefore, if you have not been heard, please go and apply to the High Court. We will make some observations. You can approach the High Court.
My lord, may I just, my normal course, I should be.
Agreed by an interlocutory injunction order passed against him, passed against it by a division bench of the Uttarakhand High Court. Interlocutory order dated 7th January 2026 passed by a division bench of the Uttarakhand High Court. One of the grievances is that the order has been passed without even hearing the petitioner. So since the High Court is now opening after the summer winter break on 9th February 2026, first we say like this, it seems to us that the appropriate recourse for the petitioner would be to approach the High Court through appropriate applications for its impleadment as a party respondent, semicolon, to seek vacation / modification of the interim order, and to bring on record the set of facts which the petitioner wishes to, set of facts on the basis of which the petitioner claims that the Song SAUNG, Song River,
It's a non.
is a non-perennial river.
Can I just, sorry.
Since the High Court is opening after winter break on 9th February 2026, we request the High Court to entertain these applications and pass appropriate orders by preponing the next date of hearing. With the liberty of formation, the specially petition disposed of.
Can I just say one thing? I don't want to interrupt, my lord. My submission is that the relevant stretch of the Song River is non-perennial. That is the permission. Lordship, that Song Rivers, that is not my contention. I have produced documents. The document which they gave, is the reach of the Song River near Sankatiawala, Kala is non-perennial. That is my contention. Lordship may say relevant stretch of the Song River. That is my contention. My contention, even when I file a reply, is not, nobody can say the Song River is perennial or non-perennial. The relevant stretch, it's a huge river. This stretch, which is what the permission is given, the joint inspection report is on record, in which.
No, your contention is that you are away from the prohibited area on banks.
Sorry, my lord, sorry.
He's saying that the place where he's.
So, Lordship means relevant stretch of the Song River. That's.
Claims that and to non-perennial. that the site where the petitioner's stone crusher, you have stone crusher,
Stone crushed.
stone crusher is operational. The Song River at that, near to that site is non-perennial.
Yes. I won't say anything for, I won't read, Lordship may read annexure P10, how this order came to be passed. I
How
won't
can
say
it be
anything.
perennial
P10,
and at one point, the river will
may
be
say-
either perennial or non-perennial?
Lordship may see annexure P10, I won't say anything, Lordship may just read it. It was supposed to be listed along with a writ petition against my rival the next day. From this matter suddenly gets detagged and get listed. I won't say anything further. P10, Lordship may kindly see. I won't say anything further.
Anyway, we have requested the High Court to prepone the date and hear you.
No,
You apply immediately and get
no, the
an audience.
consequences are grave. On one day without hearing a crusher stopped, the small entity, the whole.
Mr. Vasan, these
Yes.
are environment issues, precautionary principle guides the area.
With natural justice, my lord,
Right?
without
So
natural.
a precautionary principle, when there is an RTI report, the website of the irrigation department shows it as a perennial stretch.
Which is why hearing us, and I've given a
You
perspective.
have
Anyway, Lordship has given me
completely,
that liberty. I won't,
Lost sight of facts.
I'll leave it. But. Oblige.
Lordship, there are two matters before your Lordship, 9 and 9.1. In a similar matter, Lordship, at page 212, lecture P6,
2013 का date में
You,
same order.
double six, stroke 20.
My lords, we represent Ghaziabad Development Authority.
They are here.
I respondent 4 and respondent 3. The matter is coming out on 23rd of February.
Responder, 4 only or responder?
4 in 9, we are 4, and in 9.1, we are 3 respondent.
Accept notice on behalf of the sponsor respondent, counter affidavit can be filed before 23rd February 26.
Please,
That they will decide all.
please,
Oblige.
oblige.
Ten? There is a letter. Item 10, there is a letter circulated.
May please. Madam, this is the third time, my lord, the petitioner has been deboarded forcibly and illegally by the MP police and the RPF with the RPF police. This is the third time this incident happened, my lord. He was not permitted to travel beyond his origination.
So what can we do?
My lord, this is a
How
clear
we,
violation of-
how do we examine these facts that you were dropped on the way?
My lord, I have filed the documents, my lord, that police himself, they given that letter saying that we are deboarding you due to prevailing.
You don't have a place of protest in your state.
My lord, this is the case, my lord, where the.
No, you have a right.
Issued, my lord.
You see, we are not curtailing your right. You have a right to protest,
Yes, ma'am.
peaceful protest.
My venue is not MP. It is the venue of Delhi.
Yes.
My venue is not MP.
So-
In the midway, we were.
Mr.
we were
Consul,
deboarded.
Mr. Consul, have you applied to Delhi government authorities?
Yes, my lord, that letter I have annexed. There's
Yes.
no reply. Kindly see the letter which I annexed, 4th of October, I applied for letter. I gave a letter.
Letter
The
you gave, have you
number-
obtained permission?
Madam, permission, no reply has come.
If no reply have come, that does not mean the permission has been granted.
Well, even Lordship presume that even though no reply has come after the representation is given, that means there are no grievance for conducting dharna at
If
Delhi.
you are ready to listen to us, then you please appreciate.
Yes, ma'am.
There is an earmarked dedicated place for conducting peaceful protests.
Yes, ma'am.
There you can have a political rally, you can have a non-political rally, you can have the farmers as whom you are saying that you represent. The farmers can come there, they can protest for their demands, whatever. That's a part of the democratic process, no difficulty.
Yes, ma'am.
And for that, there is an earmarked place.
Yes, ma'am.
So first go to that competent authority, apply and obtain the permission.
When I gave a letter, my letter, there is no reply.
The
When I, after,
DCDA
when I even Lordship say that I have to apply before the competent authority, I gave a letter.
Yeah.
Even if the letter has to be given in person, I have to come to Delhi at least.
Yes.
But even half of the way, I was deboarded.
How have you, has he engaged you?
Pardon, my lord?
How has he engaged you?
My lord, he is from same place.
So for the purpose of wakalatnama, for
No, my
purpose
lord,
of.
this is not the way, my lord. Kindly see this. There is a violation, a gross violation of 19(1)D and 19(1)A.
Like to answer any question which we are asking you.
My lord, I'm saying, my lord,
How did he come to sign your wakalatnama and papers?
my lord, as a counsel, I have to sign it, my lord, that I file a writ petition on his behalf.
You are filing without any wakalatnama.
No, wakalatnama I filed, my
Is
lord.
there?
Yes, my lord.
So he came to sign your wakalatnama?
No, he sent it by post, my lord.
Oh, like, he sent it from there. Now he has authorized you. Why can't you apply?
My lord, it is duly notarized by the local notary public.
Very good. So he has sent it. Now you are his authorized representative.
No,
Not
I send it, then there is no reply. That's why my submission. my
Go
lord.
and apply, please. Ask your clerk, you can apply online nowadays. You don't know to, even you are not required to go.
My lord, I'm not saying, my lord, because the question is that the representation has been given, no reply has come.
Well, I thank you very much.
Thereafter,
Thank
huh?
you. No case to interfere with you.
My lord, at least, my lord, kindly see, my lord, the last date, last writ
No
petition.
case to entertain this writ petition is made. So ये लिखो, the writ petition is completely vague, evasive, and full of misdirected arguments. The same cannot be entertained, dismissed. ये रोज फाइल writ petition are dismissed.
Earlier, my lord, I was given permission to go to the High Court, my lord. I applied for the High Court, I filed a writ petition. There also they said we have no jurisdiction to entertain because you were deported MP.
No, but your standard does not permit to go to High Court. You are not, your standard is not less than Supreme Court. So you are rightly come
I
to
went to High Court. High Court order also I annexed, my lord. After that,
Very good.
after dismissal of the writ petition, I went to the High Court.
All right,
I
thank you.
pleaded before the High Court.
Thank
High
you
Court
very
said,
much.
"We have
Thank
no
you.
jurisdiction to stop anybody from MP, other than beyond jurisdiction of Madras. That
Thank
is the
you.
reason I have come before Lord.
All right, thank you very much. Next. Item 12.
Lordship, I apologize in this matter. I'm sorry I couldn't circulate letter on time. Mr. Sibbal, who's leading me, he's unwell. So he asked me to make a request. I got information very late. I tried to circulate, but I had surpassed the time. So I'm just requesting 1 week adjournment, Lordship. He's not well. I spoke to him. So,
Your monopoly right is expiring when?
sorry, my lord.
May 2026.
Lordship, the patent will expire in May 2026. But there was an injunction till the time the division bench passed the order. So I'm just requesting for a week adjournment. There was an injunction throughout.
Next week.
Much obliged.
But if your lordship, so far as the lady is concerned, there is no allegation whatsoever. But please come to P4 at 61. That's the FIR. And if your lordships are kind enough just to see para 7 at page number 67. Apart from the invocation of 420, 406, etc. together, Lord, just come to para 7. Complainant, may I place it? May I place it?
Para 17 of?
Para 7 of the FIR, Lord, it said FIR will begin at page number 61. I would like your lordship to see para 7.
Yes.
The complainant ultimately advanced large sums totaling multiple millions of dollars, but as market conditions surged, accused persons began dealing, eventually ceasing delivery. So the whole issue is not, it's really a commercial transaction that we could not deliver because of change of market conditions. Others are surplusage and nothing against the lady, Lord. Nothing whatsoever against the second respondent in the entire FIR. Nothing incriminating. She's just been roped in because of relationship, Lord.
What is the stage of the investigation?
Lord, I must tell your lordship, I stated, Lord, charge sheet has been filed.
Let it be investigated.
No, Lord, may I just say this? My Lord, charge sheet has been filed in the interim while the matter was pending in the High Court. Charge sheet has been filed, but I have not been served a copy of it, Lord. Charge sheet has been filed. It really makes out a civil transaction. I have not been served a copy yet because right now summons have not, process has not been issued. It's a case of not give or take of. Charge sheet was filed, Lord, but we don't have a copy. I can place that on record if your lordship permits.
Appear before the charge sheet has been filed, then go and.
I'm sorry, Lord?
If charge sheet has been filed, then go and seek your discharge as per law.
But I leave it to your lordship, but not purely a commercial matter where they say it's only a question of delay.
Commercial law depends upon that initially what were intentions. If your intentions were right from the very beginning to dupe the investors, then you can't claim it a pure commercial transaction.
There was an MOU, and I must say this, for the second petitioner, there is, not this lady, there is nothing. May I just have a look at that for a moment?
Not a case that we can question.
Lord, may I just make a request, Lord? May I make a request then? Not the concern, I leave your lordship with one more concern, but I was protected till a certain point of time. Kindly just see.
We know that is
Page
only
20.
prayer.
That will be lengthier. You will be released on bail.
Get full. And we'll take our remedies, Lord.
Absolutely.
Yeah.
The petitioners are aggrieved by the judgment dated 22nd December 2025, passed by the High Court at Calcutta in bracket Port Blair bench, whereby their revision petition seeking question of FIR number 34/2025, dated 13 July 2025, registered at Cyber Crime Police Station, South Andaman, has been dismissed. We have heard Sri Siddharth Luthra and our senior counsel representing the petitioner and preview the record. It is fairly admitted that that after investigation, charge sheet has been filed. That means so, we are not inclined to entertain this petition. The petitioners, if so advised, may move an application for the discharge. Such an application shall be considered by the trial magistrate in accordance with the law. Next paragraph. With a view to enable the petitioners to join the court proceedings, it is directed that the arrest of the petitioner shall remain stayed.
Petition number 2. First petitioner, company.
It is directed that the arrest of petitioner's number.
Petitioner is a company, Mr.
Sorry, not
Petitioner is a company.
not number 2. Second
Number
petition number. Number 2, Latifa Banu.
Petitioners
Number 2, sir.
And there's three matters, not the other individual petitioners. In matter two
Petitioners
and
in SLP criminal number 1790 of 2026 and SLP criminal number 12.
We'll give the name.
825 2026 also shall remain stayed, subject to their surrendering before the trial court within 1 week and furnishing adequate bail bond to the satisfaction of the trial court. Also, the learned magistrate shall be at liberty to impose such other conditions as may be deemed appropriate, as may be deemed appropriate.
But my lord, we make it 2 weeks is all I'm requesting instead of 1 week, because one of them is based here. Flights are sometimes a little problematic. 2 weeks.
All right, 2 weeks.
And one request for discharge will not be influenced by the observations, because there are certain observations on merits.
Nothing, Mr.
My lord. There are some observations on merit, etc.
Thank you very much. Thank you.
Grateful.